Yes.
I said I'd track down the origins of how things emerge in the process of closing. So the starting point, just for your note, I've taken you to these already. The starting point was the written closing submission. So the evidence concluded. I understand there was a short break to prepare written submissions. Those of the claimant are at page 184 of the supplemental bundle. And then I took you to the paragraphs that deal specifically with pricing, 17, 18 and 19. That refers to an analysis of 10 invoices. The analysis itself, prepared by my learned friend, is at page 194. It's incomplete in that version, but I've seen the completed version that was updated and does indeed refer to an average of £2.69 for parts.
Sorry, 1.8.
So it's
which page?
Starts at 184. The relevant written passage is 188, and the schedule is 194.
Yes.
So that is, as it stands, at 194 is dealing just with 4 invoices. There is a completed version, which I discovered last night, which actually contains an analysis of 10 invoices, which is what went in front of the trial judge. So that was written submissions were exchanged on the Friday. Moylan Jr. saw the reference to these 10 invoices, and that is what led to her train of inquiry to look into the 182 invoices. And that led to her analysis, which is at page 218. And you'll see that the original draft schedule that Moylan Friend produced referred to the first 4 invoices, but the total calculation of £2.69 referred to the first 10.
Yes.
Just so that you understand the colour coding, I'll deal with this very briefly. The pinky red is where the price is greater than £2.62. That's the original BEE analysis that the claimants had been relying upon. So 1, 2 and 4 are all higher than that one. The yellow refers to the price between £2.48 and £2.62. £2.48 was the corrected BEE price once Moylan Jr. had worked out that there were miscalculations within the BEE analysis, which brought the price down by 14p a kilo. Then green is a randomly selected £2 to £2.48, and the blue is less than £2. So whilst producing an average, the analysis also graphically indicates the general variance in pricing.
Sorry, the green was...
Green is £2 to £2.48.
I see.
And then blue is less than £2.
Is the picture of variance potentially misleading in the sense that any individual invoice may have some whole chickens and some parts, and actually if you looked at the ingredients, they were constant? Or not?
Well, we know that in fact for whole it was constantly 1.75. But that doesn't leap out at this schedule, because the schedule just gives the global average.
That's right. That is right. So it takes one so far, and the purpose of the analysis was to counter the price that comes up if you look at the first 10 of the invoices only, which is what Moylan Friend had done. And I'm not suggesting there's anything wrong at all with that, but if you look at the first 10 invoices, you get a figure that gives an average, and if you look at all 182, you get a different figure, and as it turns out, quite considerably lower figure if you take an average of all of those prices.
And just before you move on, we know we've got 182 invoices. I don't remember reading, though I probably did, how there came to be these 182 invoices.
I'm not sure that that's entirely clear to anyone. They exist. One further thing is that they relate to one customer, or one customer and two branches. And the customer is of Jourdan. You'll have seen me refer to the names before. And we can pick that up in a moment. The next stage was that there were oral closings on the Monday.
You say they relate to one or two one customer,
One
two
customer
branches.
with two branches,
Okay,
but
yeah.
one customer.
Yeah.
So that was presented by Moylan Jr. to the judge in oral closing, and I've taken you to how it was opened by her. My learned friend very fairly said, I'd like an opportunity to consider these a little further, and so the judge gave permission that there be short further written closings addressing that point, and those for the claimant are at page 223. And at paragraph 2, my learned friend refers to two spreadsheets, and you'll see 2.1, an analysis of the Jourdan cash and carry invoices. So that's the 182 from the single customer.
Yes. And
then over the page, he addresses what he's called the Jourdan analysis. And to address my Lord Justice Moylan's question about did he adopt the 182 invoices, if you look at paragraph 7, what was said on behalf of the appellant, if these prices are applied to the sales of slaughtered chickens throughout the entirety of the company's sales, applying a weight of 2.6 kilos per chicken before wastage. So that was the weight that the appellant was contending for, rather than the 2 kilos that was used in the BEE and the FSA figures. Then even if the full wastage deduction suggested by the defendants are applied, the sales turnover would be as follows. So in these supplemental closing submissions, the appellant is saying, well, you know, if you want to adopt those figures, it would produce this outcome. I hope I'm not unfairly representing that, and I'm sure my learned friend will come back.
I appreciate you I take your point that Ms. Fisher made it clear in the passage to which she was directing that her fundamental position was there was no reliable data at all. I understand that submission. But subject to that, is it correct that the position by the end of the closing submissions was that the lowest prices which were in contention were 1.75 for whole and 2.375 for parts? Subject to the global health.
The lowest price on which could be drawn from the limited documentation that was available at the point of closing was that. And so that directly answers your question. My further observation would be, and then the judge was entitled to consider whether and what weight he could safely place on those figures, given a number of factors, and I'll come on to those in due course. Yep. So, just to, if I may, conclude on ground 1, and then that detail comes under ground 2 as I understand it. So this, and your lordships have this, I know, the central submission made on behalf of Mr. Dalal was that the figures simply couldn't be relied upon. The judge decided that the 182 invoices from that period of August 11 to 13 provided a better guide to selling prices than did the 5 from 2009, which had formed the basis for the BEE method 2 and for the claim as pleaded. but he said it was not a very reliable guide, paragraph 172, page 73. And then he went on to say that it was not sufficient evidence from which to extrapolate a price for a commodity over a 10-year period. So the real complaint on ground one is not that the judge undertook a calculation based on the 182 invoices, because the appeal adopts that figure. And if you look at the relief which is sought in this appeal, in the notice of appeal, it is that there be payment of the figure which is produced by Appendix 2. So it is that the only conclusion that could be reached on the evidence was that there had been an understatement of sales, and that on one of the various grounds advanced in the particulars of the claim, Mr. Dalal should pay that. The complaint, therefore, isn't about that calculation because it's adopted. It is that the judge rejected the appellant's position that you could extrapolate a price across 10 years based on the invoices. So you'll recall that their pleaded case was that the BEE assessment had taken a price from 5 invoices and then extrapolated it across 10 years. What the appellant was saying was, having found a different price, you can extrapolate it over the 10 years, and moreover, that you must. There is no alternative to doing that.
Yeah, well, I take your point about that last point, and of course, there's also the global assessment to which you're coming.
Yes.
But just on prices specifically, where, if anywhere, does the judge say that the figures from the 182 invoices covering the period August 2011 to August 2013 are not representative of the other years? And if he did say that, what basis would there have been for it? Well, I certainly can't see that in the judgment. I've missed it. Tell me.
Well, I don't think the judge does it on that two-stage analysis. He doesn't say, can I be satisfied that that price is right, full stop, then can I extrapolate? What I understand the judge to have been doing is, can I find a figure that I can put into my Appendix 1 and Appendix 2? Then I have to take the decision, has the claimant proved its claim on the balance of probability? So the overall.
To be sure, but if you look at it in that two-stage way, it seems that he does accept that the August 2011 to August 2013 figures are representative of the entire period.
I don't accept that he does that, because he explicitly says that it is not a very reliable method. So even when looking at that, when looking at can I derive a price from the 182 invoices, he says, well, I get a price, I don't find it's very reliable.
To be sure, but in terms of just the time window,
yes,
he doesn't say, well, he's not representative of the other years.
He doesn't ever say that he concludes that it is positively unrepresentative of other years. He's saying, I don't believe it's a sufficient evidential foundation to allow me to conclude that it is a reliable basis.
But if that's correct, he wouldn't have accepted the Appendix 2 calculation, whereas he does.
Your Lordship said that before. My position remains. I do not accept that he accepts the Appendix 2 calculation.
He doesn't accept the conclusion that the claimant sought to draw from it.
I'm not sure The Appendix 2 is a form of methodology which he is testing. So he has a set of parameters, he feeds data into it, it produces an outcome. He doesn't say that he accepts that that is the right outcome, even in relation to 2009. He just says, well, look, if that's right for 2009, then there's no understatement for that year. And that then can feed in logically into, can I reach a safe conclusion in relation to the total period?
Oh, to be sure, but isn't that a separate point?
I do accept that he does not address the analysis in quite that way, but I do not read his judgment as saying, I accept that the figure of £2, I've forgotten what it is, but the figure that I find to be as good as I can get to is the right figure. It's just, this is a figure that I can get to on evidence.
So look at what he says at 183.
Yeah.
He says, applying the assessments I have made above,
Yes.
this produces a figure which is 12% higher than the total reported sales. See Appendix 2.
Yeah. But
Now, then there's still the question to which you've drawn attention to as to, well, what can you conclude from that? But in terms of the Appendix 2 calculation itself, he's accepting it, isn't he?
He's accepting that Appendix 2 produces an outcome.
Yes. And then the question is, what weight you can place on that?
But he's not saying, I find as a fact that is the right outcome when you look at the 10-year period. He's just saying that is an outcome that is produced if you feed these figures in.
If we look at 172 and 175, to pick up on my lord's first question, what do you submit the judge means when he says it's not a very reliable guide? Only three, and it's not a very reliable guide in respect to the whole period, or just not a very reliable guide overall to the prices?
He's saying the latter, and in my submission that's clear because he says that is still only 3.7 of the company's reported turnover in 11 to 12. So he's saying even if one looks at that year or that period to which the invoices relate, it's only 3.7%. It's not a very reliable guide. We know it relates to one customer only. It's not a very reliable guide, but I haven't got anything else. I've got these 5 invoices which I can place no reliance upon at all. What else have I got? Well, all I have is this, so I will do the best that I can with that, find out what figures it produces. It produces Appendix 1 and Appendix 2. Now I have to decide what conclusion on the case I can draw from it.
And if you look at 175, he says applying the above assumptions.
Yes. So he refers to...
Not findings, but assumptions.
Exactly. So he refers at 172 to assessments, 175 assumptions, and this, of course, is all in the context of the starting point, which is that he, at 117, that he's trying to make a very rough estimate of the likely level of sales. So that is the exercise he's undertaking. How does it look if I use what there is available to me? And having reviewed that, now I could consider whether I'm satisfied, standing back from that exercise, that it satisfies the burden of proof. So just two final points that on ground one. So this is not a case where the judge is coming up with a third line of reasoning, the third man argument you see referred to in the authorities. It's much more a case of finding where the balance lies between 60-40 in the personal injury example that your lordship gave. It is a way of determining whether the appellant had discharged the burden upon it to prove its case, whether there had been an understatement of facts, and that is a case that was always based on a theory and an extrapolation from that theory. The other thing, of course, is that the trial judge accepted the defendant's submission, so it was the case at trial that these figures were not something that reliance could be placed upon. Ground 2 is the gap in the logic, which really, in my understanding, is having got to a figure on a year, is one driven to the extrapolation? Is there no alternative but to do it?
I don't think that's quite how it's put. The way it's put, I understand it to be put, is that given the findings the judge made about the components in the calculation, you then get to Appendix 2, and insufficient reasons are given for rejecting Appendix 2. I mean, that's a rather crude summary.
I have to say,
and that's
you're
not one
surely
year.
right.
That's not 1 year. The whole point about the argument is that it's based on 10 years. And of course, part of your riposte to that is to say, well, hold on a minute, the whole starting point was 2009, and when you look at 2009, the case fails.
Yeah, of course. My understanding is that given that the judge feels that he can use a certain price, he can equally use it for 2009 and equally use it for the whole period, and there is no alternative to him doing so, is effectively that. And the gap in the logic is, as I understand it, that the judge didn't have evidence which pushed the other way. Now, in relation to that, one has, in my submission, to do what the judge did, and that is to consider whether the evidence that was in front of him was satisfactory. Now, my learned friend's skeleton referred to this is paragraph 50 on page 27. There was a failure to take account of the fact that 5 invoices relied upon by the HMRC and the 182 identified...
Paragraph
50, I'm so sorry, page 27 of the core, paragraph 50. So the judge failed to take account of the facts that the 5 invoices and the 182 invoices identified broadly consistent sale prices. Now, with respect, they simply don't. They are not broadly consistent. So method 2, based on the 5 invoices, originally produced a figure of £2.62. That was the basis of the HMRC assessments. Even that figure was based on a miscalculation, which was accepted by everyone, that it should have been £2.48, so that 14p difference. So the corrected BEE figure is £2.48, and that's a blended figure, so it doesn't distinguish between the whole or the part. Then, if you look at the 182 invoices, that produces £2.37 per kilo, just for the parts, and as your lordship recognised, £1.75 for the whole. Those figures are not broadly consistent. I mean, they might be if you were considering whether or not you were going to buy a notebook, and whether it was £2.48 or £2.37 wouldn't make a great difference to your decision. But what we're talking about is an 11p difference, or a 25p difference, which is magnified over 10 years of trading millions of kilos of product. So those, what seem to be inconsistent, could be said to be consistent figures, are not in the context of the quantities that we're looking at, because any variation in the price of of the assessment in relation to a part of a chicken makes a huge difference overall to the sum that is produced by that. My learned friend's position is that whatever sum comes up with must be found to be understated sales.
Well, I take your point that the figures are not consistent, but what would you say to this? That if we ask ourselves, what is the evidence of different prices outside the time frame? Now, given, I mean, this was a period of low inflation, but it wasn't zero inflation. And therefore, one starting assumption would be that prices would rise over time. So if we look at the period before August 2011, we've got 5 invoices from 2009. One might have assumed, on a pure simplistic inflation basis, that they would show lower prices than the 182, but in fact they show higher prices, not lower. And there's no, after August 2013, on ordinary inflation assumptions, you would expect prices to increase, not decrease. Certainly there's no evidence there was any price decrease in the market. So consistent in the sense that one can take the 182 as representing a floor. What would you say to that?
Well, that's exactly the sort of exercise one would expect a trial judge to be going through. And if one were putting oneself into the position of the trial judge, and you see that the figures for 2009 appear to be higher than the figures for the later period, that seems counterintuitive. And then you consider, but in 2009, based on the figures that I got, I now assess that there was no understatement of sales. You're left in a position thinking, well, I don't know, what does this evidence demonstrate? And that, in my submission, is exactly the process the judge was going through. How can I be confident that any of these figures are reliable? Because they appear to be all over the place and inconsistent with common sense ideas that there would generally be an appreciation of prices over time.
Can I ask you a couple of questions? I see we've got sample invoices, tab 5 in the supplemental bundle. Are these the 2009 invoices?
These are the 2009 invoices, and I think they're in various iterations. But,
I see.
So, and I think there's I don't know why, but for example, the first 2, I believe, are identical.
They do look identical.
So, and they've got the same invoice number.
That might be a clue.
But within the, I think there's 6 pages there. Those are the 5, as I understand it.
And can one tell from these or otherwise how far you're dealing with whole chickens and how far you're dealing with parts?
I believe so. So if you look at page 1, 2, 3, I can't. There was evidence about what all of this means, but you have the most obvious is you've got 20 legs. I suspect.
Oh, I see.
I suspect it's then thighs, and I'm not going to guess the others. Thigh meat.
So, you can't by any chance identify a whole chicken invoice?
May be able to assist on that.
These 2.
If one goes to page 473.
Sorry, 473.
473 of the supplemental bundle.
Yeah.
That is HMRC's analysis of each of the items.
Yes, I see.
And they had asked the company to identify what the various annotations were.
Yes, I see. So do we find that there's anywhere any whole chickens?
I think they are all parts.
So in terms, terms of trying to show consistency of price, you'd need to take the same part, would you, in 2009 and compare a price for 2011 to 2013.
Sorry, I understand that if you look on that schedule, about halfway down on the answers, you'll see there's an entry for skin off whole weight kilos.
Sorry, where are you?
So in the right-hand column.
Yes, I see. Yep.
So that's a whole weight, and going across that produces 180.
Yes, I see.
Price per kilo.
Yep, I see.
And I mean, Moylan Junior asked me to look at this, and my eyes had swiveled in the sockets. But you'll see
there are
that
several skin off whole weight at 180.
So you've got and you've got thigh meat and breast meat and drumsticks single.
So even for the whole weight at 180, that's higher, not lower, than the figure taken by the judge.
Than the 175.
Yeah.
Yes. In 2009.
Yeah.
If you feed in, for example, £2.48 into Appendix 2, which is the figure, the corrected BEE figure, if you feed that into Appendix 2, just in relation to the parts that leave the 175 for whole, that produces a differential which is well over 4.5 million. So these apparently small changes very quickly make a substantial difference over the lifetime of the company. So in my submission, it was entirely right that the judge should step back and ask himself the ultimate question whether he was satisfied that the evidence justified the conclusion that whatever figure Appendix 2 through its methodology produced, whether it was safe to conclude that that meant that there had been an overstatement. So those figures show how variable the evidence on price was before the court. You'll recall that in...
I'm sorry to interrupt you, but I'm intrigued by the way you phrased that. Was it safe to conclude? Was that really the question he should be asking himself? Surely the question he should be asking himself is what on the balance of probabilities is the right answer?
Or has the claimant satisfied me on the balance of probabilities that there has been an overstatement?
Well,
and that's what I'm... Because this was never a case where the defendant was saying, I have a positive case that the pricing was X. The defendant's case was there was no overstatement. And so it was for the claimant to demonstrate that there was an overstatement. And the judge's ultimate question was, am I satisfied on the balance of probabilities that the claimant has proved that there was an overstatement, or an understatement of sales? And he wasn't, and he was entitled to reach that conclusion. Other examples of variability. So you've seen what my learned friend said in his closing submissions. Based on the 10 invoices, he was pointing to a price of £2.69. The judge also had in mind that the figures for 2009 had not produced evidence of an understatement by applying Appendix 1, and that's clear from the last two entries on page 85. Even looking at the 182 invoices, the passage we've just been looking at, the judge notes that that accounts for only 3.7% of reported turnover for the relevant period. The invoices relate to sale prices of £135,000 and the reported total sales that this was supposed to cross-refer to was in excess of 30 million. Looking at that approach, the 182 invoices accounted for only 0.004% of total sales.
So 0.004%.
0.004%.
Yeah.
Now, my learned friend opened his submissions by pointing to the reliability that could be placed upon other aspects of the calculation. And in his skeleton argument, he challenges the judge's point at paragraph 117 that there is substantial uncertainty about a number of aspects of the calculation. That's what the judge says at 117. Learned friend says that there weren't. It only related to the sales price. I respectfully disagree. If one looks at page 70, in the core bundle, the judge at this point is looking at the adjustment needed for wastage. At paragraph 156 at the bottom of page 70, the judge says, there is therefore substantial uncertainty about the right percentage to use. That is a point where I would have been greatly assisted by more evidence. In the absence of any other more reliable evidence, I propose to take that figure of 72% as a reasonable estimate. And at 162, learned friend took you to the conclusions at 163, but immediately prior to that, the judge says at 162 line 4, there is therefore very substantial uncertainty about the right percentage to use. This is another point where I would have been greatly assisted by more evidence. In the absence of any more reliable evidence, I consider it appropriate to undertake a calculation on a certain assumption. So that's the basis that he adopts a figure for wastage and feeds it into his appendices, so his methodology. So the judge is quite right to say at paragraph 117 that there are a number of uncertainties. He identifies it here for wastage.
What do you say to the point that if you'd taken your client's evidence, he would have actually resulted in a lower figure? Because your client's evidence was the wastage was around 40%, and the calculation he produced gave 42%.
That is, if I may say so, a submission by my learned friend which slightly misses the point. What the judge is saying is there was very substantial uncertainty. I've done the best that I can on the evidence. I think there could have been better evidence, but I'm doing the best that I can. So I feed it into a methodology, but recognising that there is uncertainty within it.
But your client didn't say the true figure is 60% or 70%.
And I'm not.
Your client's own evidence was the true figure was around 40%, and the judge's calculation actually comes out with a higher figure.
I'm not seeking at all to go behind that. What I'm seeking to do is justify the judge's, which have been criticised, the judge's observations that he felt that there was uncertainty about a number of aspects in the figures. So he does reach a point that he feels he can be satisfied will go into his spreadsheet, but he's not satisfied with the basis of the evidence that he's had. Now, I'm not saying that my client got it wrong or that my client wasn't getting a reasonable outcome by this particular assessment. That's not the issue. The issue is why was the judge saying that he felt that there was uncertainty about the figures? And here he's saying, I thought there could have been better and clearer evidence. And similarly, there are a number of passages in the judgment. So, for example, in relation to bad debts, page 73 at paragraph 176, says there's very little evidence on this issue. He does accept Leonard Jr.'s suggested figure. But again, what the judge is saying is, I don't feel that I've got any confidence and certainty about these figures. So the defendant's not trying to put forward a counter-analysis.
But I'm baffled by that. So the figure comes from the defendant's own accountants when instructed to investigate the HMRC claim. So it's not a figure that comes out of thin air. It comes from the defendant's own accountants investigating the MRC claim. It's adopted by defendant's counsel in closing submissions. Claimant's counsel agrees with it. So why on earth is that in any way an uncertain figure?
Because the judge is saying, normally in a case which involves an assessment of bad debts, you would have a very detailed analysis being done of specific figures that have been pulled together over the period of the life of the business, because you'd have a set of the underlying documents and you'd be able to do it that way. And then the judge would say, well, I've got absolute confidence in that figure. What he's saying is, well, everyone's telling me it's going to be 2%, so I'm not going to second guess that, but I haven't seen any underlying analysis in relation to it. It's not exactly an agreed figure. It's everyone saying, well, what other figure can one come up with? That's the best evidence we've got. Everyone's saying it's the best we've got, but it's not brilliant. And so the judge is perfectly entitled to say, well, I don't have particular confidence in that figure, but I'm going to use it for the purposes of my methodology. So in my submission, the judge is perfectly entitled to say that there's a substantial uncertainty about a number of aspects of the calculation. There's another one in paragraph 179, the amount of cut meat sold, no evidence as to whether the birds purchased for cutting were delivered with byproducts. So littered throughout, there's a layer of confusion. The second criticism about paragraph 117 is it said, here at this point the judge says, I've considered whether the evidence is so thin that I should simply determine that it is insufficient to make any rational decision. In the end, I've decided that there is just enough information for me to make a very rough estimate of the likely level of sales in the year ending 30th of September 2009, which can be compared. Now, that, my learned friend says, well, that should have been applied as the ultimate question. In my submission, this is not. This is going to a different point. The judge here is saying, does the evidence allow, in relation to 2009, a rational decision to be reached? If not, then the case fails, because there's just no evidence. If there is evidence to allow a rational decision, then what is my conclusion on the balance of probabilities? They're separate questions. Is there any evidence on which I could reach a conclusion? If so, what is my conclusion applying the balance of probabilities? My learned friend seeks to conflate these and suggests that the ultimate question is there enough evidence to make a rational decision? And implicitly, there is only one rational decision. Well, there isn't, because the judge has to assess the evidence that he does have in reaching the ultimate conclusion on the balance of probabilities. So the judge reaches figures for 2009. He finds that these demonstrate no understatement for that year, Appendix 1. But he was not satisfied that the extrapolated figures for 10 years were such that he could place reliance upon them. There's no inconsistency with that in paragraph 117. This is a case which is, as I briefly explained earlier, it is a case which is based on circumstantial evidence. There is no evidence whatever of the misdirection of monies. It is based on an hypothesis starting with the number of birds being slaughtered as recorded by the Food Standards Agency. What the court then does is undertake a systematic analysis, applying its methodology, producing spreadsheets of appendices 1 and 2, and at the end of that process, the judge stands back and asks himself the ultimate question, whether he's satisfied that the suggested explanation, that there's been an overstatement of, an understatement of sales, is more likely than not to be true. And that approach is wholly consistent with nullity, and it is something that this appeal court in my submission cannot interfere with. On the question of ground 3, there's not really much more to add on it in my submission. This is whether the wrong approach was taken to the burden of proof. My learned friend has contended that the trial judge established on rational and objective grounds that the total sales were 3.7 million than those appearing in the accounts. And you'll understand my submission is that that is not the case. He did not establish that those were the total sales. He applied a methodology. He applied it to 2009. He applied it then over 10 years, and he then considered whether it was safe to rely upon the calculation. My learned friend also says that there was no evidence to undermine the sales price taken from the 187 invoices. In my submission, that's not right, given the inconsistencies that there were with the evidence that was before the court. There was a variety of evidence that did not show a consistent and reliable sales amount. The invoices were for a small sample across a short period, and the judge was perfectly entitled to accept Mr. Dalal's submission that this meant that weight could not be placed upon those figures such as would satisfy the burden of proof that was on the claim to prove its case that there had been a substantial understatement of sales over a period of 10 years. Lords, I was going to turn to ground 4. Clearly, the relevant case is that of Mumtaz. Perhaps we could look at the authorities bundle. It's at page, it's the first case, and it's at page 8 is the relevant passage. Paragraph 14, which regrettably was not a highlighted paragraph, in the judgment, it starts off by looking at the legal context. Contemporaneous written documentation is the very greatest importance in assessing credibility. It can be significant not only where it's present, it can also be significant if it's absent. This will not be a revelation to the court. So absent, where it is absent, paragraph 15, that was the predicament in this case. The liquidator could not show that Munir and Zafar were de facto directors from the company's books and papers because the directors had not handed over the necessary documents to the administrators. There's then a reference to the trial judge, and then at paragraph 16 over the page, the approach of the judge in this case was to seek to test the evidence by reference to both the contemporary documentary evidence and its absence. In my judgment, this was an approach he was entitled to take. The evidence of the liquidator established a prima facie case, and given that the books and papers had been in the custody and control of the respondents of the proceedings, it was open to the judge to infer that the liquidator's case would have been borne out by those books and papers. Put another way, and paragraph 17 is the passage my learned friend relies upon, put another way, it was not open to the respondents, in the circumstances of the case, to escape liability by asserting that if the books had been available, they would have shown that they were not liable. Moreover, persons who have conducted the affairs of limited companies have a high degree of informality, as in this case cannot seek to avoid liability or be judged by a lower standard than that which applies to other directors simply because the necessary documentation is not available. Now, my learned friend says that Mr. Dalal was in default in delivering up company records, that the judge somehow gave Mr. Dalal the benefit of the doubt, and that offends against those principles. I don't understand how my learned friend asserts that Mr. Dalal was in breach of his legal obligations in failing to produce the company records in disclosure. As the judge noted, at no point during the course of the litigation did the appellant complain about the disclosure. Mr. Dalal was not cross-examined on the basis that he had withheld documents from disclosure. And so he had no opportunity to explain whether they existed or what had happened to them. So there's no basis for a conclusion that there'd been a deliberate withholding of relevant documentation, but more importantly, the judge doesn't reach that conclusion. I'm unclear as to how it's said that Mr. Dalal was given the benefit of the doubt in the way that the directors or the alleged directors in Mumtaz were seeking to have the benefit of doubt portrayed in their aid. This is not a case which was presented squarely as one in which a detailed audit was required of the company's accounts, or that Mr. Dalal had failed properly to disclose the company's records. That isn't how the case was put. If it had been, then one could see where this criticism would lie. The judge made the point, and this is all I will say on this, at page 356 of the supplemental bundle. You'll see that the second, letter B, these are my learned friend's submissions seeking permission to appeal. And at that point, he's referring to a director not being able to take advantage of the inadequacy of the records and so forth. That's the context for what the deputy judge says just before letter F. I'm going to refuse permission to appeal. I consider that the aspects of my decision which you've identified were evaluations of factual material, and in the case of the point you've just made, my assessment, so the point that was just made was about the documents, my assessment was that the way the case had been put, really right until the end of the trial, was firmly on the 2009 year, and there's never been any suggestion of a failure to provide documents in respect of other years. So that's what the deputy judge said when he was refusing permission to appeal on this. So
one oddity I haven't attempted to understand is this was a company that went into liquidation
in 2015.
In 2015. At that point, all the records should have gone to the liquidator. So on the face of it, it wouldn't be a matter of disclosing them in this litigation. They ought to be disclosed to the liquidator.
Yes.
Evidently, they didn't reach the liquidator.
I don't know the answer to that. I don't know what might have happened to them in the course of the period following that time. And that would be something that if one was seeking to rely upon this point, one would have very carefully to go through in evidence with the relevant witnesses what documentation was available. So it might be that there had been a non-production of documentation, wholesale failings. If the documents had been produced, where were they? Had they gone to the liquidator? If not, why not? Had the liquidators retained them? Had they passed them over? Huge amount of detail that would need to be gone into before a judge could be in a position to draw an inference that there was a deliberate withholding in order to hide the fact, effectively, that there had been an understatement of sales. And it would have to be a core part of the case that was being presented by a claimant, so that evidential background could be explored in significant detail to allow the trial judge to reach conclusions on this, not as a sort of side wind. And the trial judge's position was that there's never any suggestion of a failure to provide documents in respect of any year, perhaps other than 2009, where we know that there are 5 invoices. So in my submission, it doesn't get to a point where we're in Mumtaz territory, which of course properly states the position and is something that one frequently relies upon at trial. The final point I make by way of conclusion is this. The way in which the appeal is put is, as I've said, that if the sales were understated, then the appellant says it must be entitled to recover the amount of the understatement from Mr. Dalal. Quite how or on what basis is unclear. How one gets from, well, if the trial judge was wrong, that there must have been an understatement, and that understatement is something for which Mr. Dalal must account. Your Lordship's made the point, and I'm not going to shy away from it, and I will address other points in relation to it. But the judge does say that he didn't find that Mr. Dalal was misleading in his evidence. Now, Mr. Dalal
says Mr. Dalal couldn't remember anything.
Well, he does say that, but someone who is deliberately understating the sales of a company to the tune of 3.5 million or 36 million.
I mean, correct me if I'm wrong, but I understood from Mr. Shaw, and I haven't found it in myself in my searches, but maybe both of us have missed it. There's nowhere in the judgment where the judge says Mr. Dalal denied misappropriating the company's money, and I believe him.
No, the judge doesn't say that, because he doesn't actually get to that point, because he says, well, I'm not satisfied that there was an understatement of the sales. So that's the end. Sure. So he doesn't have to go to that further stage and analyse the last stage of the claim, which is if there was an understatement, what are the conclusions that I should draw from that? And where does liability fall, and on what basis? So
sorry, we seem to be, and it may be my fault, in which case I apologise.
I'm sure it's
mine. We seem to be mixing up two different questions. One is an evidential question, and the question of, in reaching his conclusion as to whether or not there was an understatement of sales, and if so, the extent of that, the role of Mr. Dalal's evidence in that. And so that's question one. But then there's question two, which is a legal question, which is if, contrary to the judge's view, it is proved on the balance of probabilities that there was an understatement of, let us say, £3.5 million, then is there liability on the part of Mr. Dalal?
You're absolutely right with respect to that.
I didn't understand that legal issue to be in dispute.
Well, I don't understand myself how it is being put, because all that is said in the notice of appeal is that the substituted order should be that the first defendant pay the sum of 3.7 million. So effectively saying if the trial judge should have been driven to find that there was an understatement in the figure of 3.7, and therefore we're entitled to be paid it. That's what the notice of appeal says.
I do wonder whether here the pleadings do come in, because when faced with a claim by the company that you've taken money, you can say, as these defendants do, well, there was no money to take. Or you can say, well, there was more money and we took it, but we were entirely entitled to do that. But they never say that. They say there was no money to take.
That is a very fair point. They are saying that there hasn't been an understatement of sales, full stop.
So then coming back to the other issue, the credibility issue, there's been reference to your client's evidence. Obviously, Sajid and Anisha also gave evidence. They were found not to be de facto directors, but that merely means that they weren't involved in the key decision making.
Yes.
That doesn't mean they weren't involved in the company. What can one conclude as to what roles they played in the company? Would they have known about diversions? Was it put to them that they did know about diversions and they said no, or what?
Well, that's exactly the problem I'm seeking to identify. Even if the trial judge ought, and I'd say he was perfectly entitled to reach the conclusions he did. But if the trial judge ought to have found that there was an understatement of sales, and that is what the subject matter of this appeal is, I don't understand how it then gets to an order, which is the order that is being sought, that there be a payment of that figure by Mr. Dalal to the appellant.
I think what I'm concerned with at the moment is the other question.
Oh, all right, the credibility point.
The credibility point. So you and my lord have referred to your client's evidence. But there were other witnesses who themselves had involvement with the company.
Yes.
So one might think that they could be expected to have known about diversions, even though they weren't de facto directors.
Yes.
But I certainly haven't tried to work out exactly what they might have been expected to know, how deeply they were involved in the company, what was put to them, what they said about it.
Yes. And I mean, the difficulty that one is in is that the judge doesn't go through that analysis because he doesn't need to.
Well, you say that, but the inference I drew from what he said about the assessment of the witnesses was he didn't think they helped, and therefore he had to rely upon the documents. And again, it's the same with Sajid and Anisha, if I may be forgiven for using their forenames to identify them, because one doesn't find in the judgment any statement to the effect of, well, they denied that there was misappropriation, I believe them, nor indeed do you find the opposite. He treats their evidence, once he's acquitted them of being de facto directors, he treats their evidence as essentially irrelevant. And as I understand, it's on the footing he didn't think they could help.
Well, help with that part of the assessment that he was undertaking in the context of this, in the context of what is now being challenged.
I say that's an overstatement. There are one or two references to Sajid's evidence, but apart from that.
Yeah, but they underlying this is that if there were a massive understatement of sales, which no doubt they would have been challenged on by my learned friend, they would have to have been. The finding of the judge is simply that he found that he didn't think any of the witnesses were giving evidence they believed to be false. In my submission, it's impossible to align that with a conclusion that the three of them, or one of them, we don't know which, because that's not what the judge finds, were somehow involved in misappropriating the funds over a 10-year period, or that one of the three of them had been deliberately understating in an obvious way sales of this order for nefarious purposes. They could not but have been asked about it. They could not but have given evidence upon it. And to the extent that they do give evidence, the judge considers that they didn't give anything that they believe to be false.
I mean, just glancing at the witness statement, Sajid at least must have been asked about it, because he says in his witness statement, I do not think there were undeclared sales. So he must have been challenged.
Well, exactly. I don't have it to hand, but there's a passage where Mr. Dalal is asked, my client is asked about whether or not there's been an understatement, and by reference to the document that's in the bundle, which is an acknowledgement to an extent that there may have been an understatement and so forth, and he's asked about it. So it's you know, and even if he said, I can't remember, that would be in the context of this case, where there's it's an allegation of serious wrongdoing. That would be a fanciful answer if you said, well, I can't remember. It's not just, well, you know, I can't remember exactly what we were selling chickens for in 2007. But if you're asked the overall question, were you deliberately understating the the sales over a 10-year period. You couldn't honestly answer, well, I can't remember. Or the only answer could be, I can't remember or no, and I can't remember is fanciful.
And to be unfair to you, we've got various transcripts in this bundle. Can we identify in the transcripts any passages where it is put to your client or indeed any other defendant? Something along these lines.
I was looking at it over lunch actually, and I don't think I took a note. So, for example, in page 288 in the supplementary bundle, so this is at page 13 on that page 288.
And this is your client being
This is my client being cross-examined. Mr. Dalal, line 5, there is a big difference between what's said at page 49 and 428. At 49, there's an acknowledgement of some innocent mistakes in the accounts. At 428, you're admitting to deliberately causing a loss of tax by under-declaring your sales. That's right, isn't it? Today, I don't remember everything at this age now, and I can't read or write English, so it's difficult for me to say anything. You knew by the time of this document in 2013 that you had deliberately under-recorded the sales in the company's accounts. That's right, isn't it? Answer, according to my understanding, since I came to England, I've not done any wrong work. I'm old now, but I know I've never done anything wrong. Now, if someone were, so he's saying I've never done anything wrong, to the extent that he's saying I don't remember, if it were being suggested that he can't remember serious wrongdoing, then that couldn't be a credible answer. And the judge finds that to the extent that he gave answers that he was satisfied by them. That's one example, and there are obviously others, because my learned friend, I've no doubt, not seen him, but I've no doubt he knows how to cross-examine on a case like this.
Yes.
My lords, are there any other?
Anything else?
No.
No, thank you very much. Yes, sure.
A few points by way of my learned Lord Judge Arnold puts to my learned friend that the judge doesn't address the question of whether the 182 invoices, or for that matter the 5 BE invoices, were unrepresentative. And that, in my submission, is one of the fundamental difficulties with the reasoning in the judgment, is that it simply doesn't engage with that issue. So it's left, in a sense, hanging. That can be allied to the second point, again, my Lord Justice Arnold puts to my learned friend, and that is, whilst there are invoices in the 5 invoices in 2009, they show higher prices than those in the more extensive ones in 2011 to 2013. And the analysis that my learned friend did of the entire 182 invoices, of course, showed a lower average price across either the cut-up chickens or the whole chickens than the more limited exercise that had appeared in my closing submissions. What the judge has, of course, done in his analysis is effectively, with these variable possibilities as to sale price, given the defendants the benefit of the doubt in terms of the conduct of that examination. He's taken those figures. They are the lowest of the average prices that were in evidence, and he's applied them. Now, my submission, he was perfectly right to do that. Where he went wrong, in my submission, is that he didn't follow through the logic of what he had done. And he misapplied or failed to follow through his observations at paragraph 117 in relation to whether there was a sufficiency of evidence entitling him to make findings. If he had followed through that, then on the basis of his analysis, he would have stuck with the conclusion that there were significant underreporting of sales. Manolete made the point that the judge's comments concerning uncertainty of the evidence were not limited to sale prices. He referred to the wastage as an example, and again, as my Lord Justice Arnold points out, what the judge was doing was accepting a matter that wasn't in issue, because everybody had agreed. The defendants, accountants, the defendant and the claimant had all agreed that the appropriate level of wastage was 40%, or accepted that the finding was 40%. The same in relation to bad debts. My learned friend also made the point in relation to the judge's observation at paragraph 179 concerning the cut meat. If I could take you back to that one. This is at page 73 of the report bundle, over to 74. Where he says there was no evidence as to whether the birds purchased by the company for cutting were delivered by, with or without byproducts. In the absence of such evidence and given the burden of proof, I'll assume the birds were delivered with byproducts and therefore an appropriate wastage adjustment ought to be applied. There's no challenge to that. There's nothing wrong with it as an analysis. It's entirely consistent with the rest of his analysis, namely that in a process of cutting up birds, there will be a wastage element. That again is an instance of the judge accepting the defendant's evidence. That's not a question of there being any uncertainty, or if there was an uncertainty, it's an uncertainty that's resolved in the defendant's favour. I think the last point I want to make, subject to any questions your lordships have, and subject to one other matter, is in relation to the Mumtaz point. And it's this. Mr. Dalal was the director of the company and was under an obligation to deliver up books and records to the liquidator. There's no question but that they weren't delivered up to the liquidator.
Well, how can you submit that?
It was common ground. There's no issue between the parties that the books and records were not delivered up to the liquidator.
Does that feature in the judgment?
It doesn't feature in the judgment, but it wasn't a matter that was in dispute.
Well, so it wasn't a matter that was raised. I mean, I'm not saying whether it was just not an issue that was addressed at all below. No evidence. No. I mean, you. Okay. Well, anyway.
Well, it wasn't. It wasn't material that was the liquidator. That Mr. Dalal hadn't delivered up the material, and I say it as a matter of legal principle, where he is seeking to rely in this case on the inadequacy of the totality of the company's records. That is a point that ought not to carry a lot of weight, and I put it no higher. I said there was one other matter, and that is, I realised over lunch that I had given an inaccurate reply to my Lord Justice Moylan's question to me about what I had put to Mr. Dalal as to the representative nature, if I can put it that way, of the invoices. And I realised, looking at transcript again over lunch, that I had put that to him in perhaps in slightly clearer terms than I had thought.
Where are we?
In the supplemental bundle, page
Yes.
296.
296. Yes.
I had been taking Mr. Dalal from the top on page 45, top left,
Top
to
left.
various of the invoices.
Yes.
And then at the, page 47,
Yes.
I put to him the question I was asking Mr. Dalal was, at these various other dates that we're looking at, the price of chicken parts are consistent.
Sorry, haven't found it yet. Where is
I'm so
that?
sorry, just above page 47, on the right-hand side of the page.
Is the okay? Yes.
Line
It is,
23.
yes.
Prices we've
Sorry,
seen
it might be
consistent.
helpful to start higher up, because I see that you began with the Watan invoices,
Yes, well,
and that gives us the context.
that's the context.
Yes.
And you'll see in that first round of question, that first question at line 5, my question to Mr. Dalal, those prices we've been looking at different dates are typical of sale prices for these chicken parts. And in the 2009 exercise, the sample was not unusual. Then there was some interruption.
Yes.
I repeat the question. And his answer, he says, I know that you are talking about now, but at that time lots of different kinds of situations can happen. Like maybe there was more illness, which presumably is a reference to the level of illness in birds. There was more waste, level of wastage. Shopkeeper would take the money and run away. That's a bad debt point. We provide you with books and paperwork according to what we've got. And then the question goes off on another line about who negotiated sales and so forth. So he has the opportunity of addressing that point and doesn't. My Lords, unless there's anything further, those are my suggestions.
Well, are you able to shed any further light on the question that my Lord Justice Newey was debating with Mr. Leaper towards the end of his submissions about the oral evidence and the extent to which it sheds light on this question or not?
So, insofar as concerns Mr. Dalal, the defendant, yes, I was put to him that there had been a deliberate understatement. You saw the answer that he gave to that. That doesn't take this court much further forward in terms of its analysis of whether the judge was right in his approach and the conclusions that he reached. And his absence of finding as to Mr. Dalal's motivation, whether he had knowledge or anything of that nature. There's no assistance that you gain from that. What I say in terms of ultimate remedy is that if your lordships are of the view that the judge was wrong and that he ought to have stuck to the under declaration point, then I say it follows that there had been a misappropriation. In a sense, whether deliberate or not, whether it was as a consequence of bad record keeping or purposive misappropriation. The point is that, of course, as a director of the company, he has an obligation to account to the company for its receipts. And if he's not accounting to the company for its receipts, then on ordinary principles, he ought to be liable. Now, those aren't matters that the judge dealt with, and I agree with my learned friend when he says, well, given the nature of the judge's judgment, he stopped where he did. In my submission, it would follow that if your lordships accept my submissions, that Mr. Dalal ought to be liable for the sums that he did not account to the company for.
And just as to the other defendants, Sajid and Anisha, at least in Sajid's case, it must be the case that you put to him that there were diversions.
And that similarly doesn't take the exercise any further as to what I did or didn't put to him, or what he did or didn't say to him. Firstly, because that wasn't an issue that the judge addressed or needed to address given his findings A, in relation to Sajid and Anisha, and B, in relation to misappropriation generally. Secondly, for the reasons I've just submitted, that even if there were misappropriations, and even if their position was, well, they knew nothing about any of this, that doesn't alter the position vis-a-vis Mr. Dalal Senior.
I wonder if it's quite as simple as that. On one way of looking at this, I think it's sort of the way that you're suggesting. The judge stopped at his assessment of the various figures, and you say, well, he should have stopped there, and he should, on that basis, have given judgment in your favour. But suppose that he hadn't stopped there, it would then have been incumbent on him to weigh whatever he thought about those figures against the evidence given by the defendants. And that wouldn't just be this defendant's evidence. It would have to be the evidence of the other two as well. And in that context, he would have to consider what roles they'd played, whether they could be expected to have known about diversions, if he still believed them when he said that he didn't think they were being deliberately untruthful.
Well, my lord, that would depend on his findings as to their status as de facto directors.
Well, no, it wouldn't, because I think he says somewhere that, that they may have been senior managers or something, but they weren't de facto directors. Well, a senior manager could be expected to know about diversions, whether or not that senior manager was a de facto director.
I understand that. The question then would be is how that would play out in terms of the allegations against them.
Well, also against this defendant. Because if they could be expected to know of diversions, not because they were de facto directors, but because they were involved in the company. If they said they didn't know of diversions, and if they were believed, that doesn't just mean that they're off the hook, it means that this defendant is off the hook.
I think my response to that is not necessarily, because of course that depends on an inquiry as to their respective roles, which I accept is the point that your lordship is making. That's not that of course wasn't something that the judge entered into, and I think we'd only be in a position where we'd be speculating as to what possible findings he might have made had he engaged in that exercise.
Well, if that were right, then it's a bit hard to see why you should get judgment in your favour on the basis of the arithmetical exercise, disregarding what the judge might have thought on these other matters if he had gone on to consider them.
Well, that's because there's a fundamental difference between Mr. Dalal, this defendant's position, and that of the second and third defendants, by virtue of him being a de jure director, as the judge wasn't an issue, and the second and third defendants not being, and the judge finding that they're not de facto directors. So, whilst that one can see that the question of their role would be relevant potentially to questions of their liability, and even if they step out of that, of being in the frame for liability, they wouldn't be relevant, my submission, for the purposes of assessing Mr. Dalal's liability.
And that I don't understand. If they could be expected to know about diversions, and they say they didn't, why isn't that relevant to whether there were diversions? And the question of whether there were diversions is absolutely key to this defendant's liability.
Well, the question of whether they're expected to have known of diversions, of course, involves an analysis of what their role was. I appreciate there's something circular about this. The judge doesn't make findings as to he makes findings, of course, that they weren't directors, de facto directors. He doesn't make findings of the nature that might say, well, they were in a senior position and therefore they ought to have been expected.
Can you remind me where in this judgment we get the de facto director bit?
It's
starts at page 55.
55.
starts at 55, where he sets out until paragraph 71, page 57, legal principles.
So the roles of these defendants didn't change when they stopped being jury directors. And if you look at 82, Mr. Shaw pointed to the fact that Sajid was a signatory. That's correct, but I consider it something that a trusted senior manager might well do. So he could be a trusted senior manager.
Yes.
And then he might be expected to learn about diversions. And if he said he didn't and was believed, that helps this defendant as well as these, Sajid and Anisha.
I see theoretically, yes, I see that theoretically. But in terms of fact, given the scope of the findings of fact that is made by the judge, my submission doesn't take anyone in at this stage of the exercise. I could see that at trial, it could have been relevant. They could be relevant consideration, but not at this stage.
I'm sorry to make just one point, which is Malone Friend said that it was common ground at trial that the first defendant had failed to deliver up the books to the liquidator. I understand that it was not common ground at trial.
Thank you.
Sorry, can I ask about that? Was it common ground? That's sort of ambiguous.
It wasn't intended to be, just for the avoidance of doubt. It was intended to be succinct.
It might mean it was common ground that there had been no... that it wasn't common ground that there had been a deliberate withholding, but it might still have been common ground that no records were actually delivered up.
I think even that wasn't common ground.
Well, if they had been delivered up, the claimant would have been bound to have disclosed them.
My understanding is that privilege was claimed as between the company and its representatives and the liquidator. That's what I've been told.
I don't understand that.
I'm
Can't
not-
be any
I'm not
privilege
sure I
in
do.
respect of sales documentation.
That's what I've been told is the position.
So let me be clear. Your understanding is that there were documents that were passed to the liquidator and were not disclosed by the claimant in these proceedings because of some assertion of privilege.
So my instructions are that Mr. Dalal's position was that he had delivered up records to the liquidator. Beyond, so that's why it isn't common ground. Beyond that, I'm not sure it's... we don't know what happened to them.
Okay, thank you.
All right, so there's a theoretical possibility, to put it at its lowest, that documents were lost.
There may be a range of explanations, but that's why the point that I was making is it was something that one would carefully explore at trial with the witness to try and understand what exactly had happened and who was responsible.
Thank you. Thank you all very much for your submissions. We're going to reserve our judgments, which will be provided to you in draft in the usual way for you to correct in the usual way, not to use for any other purposes in the usual way, and you know the consequences if you do now. And we would hope that once you've received our draft judgments, you'll be able to agree in order, but if you can't, we'll deal with any outstanding matters on short written submissions. So thank you all very much. Thank you.